And happy Friday, everyone. Welcome to the Wall Street Blockchain Alliance's weekly crypto roundup. Today is Friday, August 25th. I am Ron Quaranta, chair of the WSBA, here with the one and only Joshua Ashley Klayman, my co-host and member of the board and chair of our legal working group. Shout out to our co-host, David Brill, who couldn't join us. He's spending some quality time with family in the waning days of summer. Before we begin, for everyone in the audience, obviously, please do keep in mind nothing discussed is accounting, investment, legal, or tax advice. Please put your questions to the chat. Josh and I will be happy to try to answer them as best as we could. Josh, good to see you as always. Never a dull moment. And as you and I were joking, stack of things to read, like right after this broadcast. How are you and what's going on?
I'm great. I mean, as you said, things continue to be fast-paced, whether with deals or with the news or with all kinds of other stuff. So yeah, there's definitely a lot going on. What's keeping you up at night, or what are you excited about?
Just when I think I'm getting a handle on some of the stuff around draft legislation that's being proposed and regulatory enforcement actions and all of this interesting stuff, we see the big things that kind of explode during the week. And one of the things I thought we'd start talking about, U.S. charged tornado cash, I think very recently this past week, and it was very much focused on Tornado Cash and the founders of Tornado Cash helping with sanctions evasion, particularly for North Korea. And Josh, you and I have had this conversation in our legal working group. Dina Ellis, shout out to Dina, and others in the group. Adam Goldberg, shout out to him as well, who really focus on one of the challenges from a justice perspective, a DOJ perspective, will be national security and things like sanctions evasion. Do you want to talk a little bit? What are your perspectives on this kind of Department of Justice action against Tornado Cash? And in fairness, a lot of us believe Tornado Cash a little bit of a dangerous place to play, but I'd love your thoughts from a lawyer's mind.
I mean, that's a dangerous thing today of all days. But I would say, one of the important things to remember here is that as we have the arguments, which are very valid arguments about smart contracts and freedom of speech and different types of protections that are available to citizens and others, right? And trying to differentiate between technology and persons, for example. I think we see in various areas the US government at least, trying to find ways to hold people liable. And so even though there's a in many instances, visceral reaction to holding developers liable, I think that here the government is trying to show a message, right? Even as it's continuing to fight different areas of the government, right? Continuing to fight about the overall, the sanctions against, the case that was brought in respect of the sanctions against Tornado Cash itself.
Yep.
Which we understand, we have some information about now, but we've heard will be appealed. I think this just shows that the government is trying to say, you can't hide behind these technologies. There are people there. There's somebody who put these things into motion. So in charging with the two persons, two of the three founders of the Tornado Cash service, and saying that they were engaged in, among other things, different forms of conspiracy. I mean, this conspiracy to operate, as it was described, an unlicensed money transmitting business, which has, potential maximum sentence of 5 years in prison, conspiracy to commit money laundering, and conspiracy to violate the International Economic Emergency Powers Act. Each of which carries a maximum sentence, I understand, of 20 years in prison. I mean, these are big charges. And again, I think it is, in part, yes, there's the alleged involvement with North Korea, right? Which, of course, is
not a good thing, yes.
Right. But I think also it's trying to show a message that these are serious crimes or serious alleged crimes. And that, again, the government doesn't want people to believe that they can hide behind technology.
Josh, it's interesting. In our meeting, our last legal working group meeting, this kind of, for me, touches on this broad topic we've been addressing. And certainly sanctions evasion is a really bad thing. But it looks like a lot of what we're talking about, I'm going to co-opt some Howie language. You're going to kill me for this. But efforts of others. And one of the things I've joked about is, how do you define others? Same thing with developers. One of the arguments for several in the industry have been, at least worldwide, has been this idea that, well, developers, they're just developers. They're just developing technology. From your perspective, are we looking at the evolution of how governments around the world, law enforcement agencies and regulators view who participates in markets? And that opens up a big can of, how do we define efforts of others? For example, what's the role of developers? What are the role of accountants or lawyers? We've seen these kind of comments from regulators that say, hey, accountants and lawyers, be careful what you advise. And I've never met a lawyer who's not careful about what they advise. But do you see this kind of evolving perspective of other industry participants? You need to understand your role in all of this. Does that make sense? Is that what you're seeing as well?
I mean, I think that's a good way of putting it. I think if you think broadly about the gatekeepers, as you mentioned, the way they've been singled out or highlighted by various regulators, I think that's important. I think also, and this comes up in numerous instances, including, for example, UkiDAO or the predecessor to UkiDAO, BZX DAO, or even in the case that was brought in respect of Tornado Cash itself, right? With some of the judicial reasoning. This idea that, okay, we're also potentially going to look at governance token holders. We're also going to look at a DAO, right? To say that you cannot, at least in the regulator's view, that there are, especially if there are matters of national security, that there are limits to which you can just put something out there and say, it wasn't me. I'm not saying that's what people are doing, but I think that is a concern. And as the industry, in various ways, continues to push back with often excellent arguments as to why the limits to government reach should be respected, I think the government is also trying to bolster ways to still hold people responsible.
Right. Josh, thanks so much. Shout out to Trevor and Kevin. Thanks for joining us. Anyone in the audience, again, we're going to make this a relatively brief session. Josh, I assume the Gulfstream 4 is powered up and you've got to fly to new deals that you're working on. I likewise am drowning a little bit in some of the work that the WSBA is doing. So we'll make this a relatively brief session. Josh, I'd love to kind of flip that argument around a little bit. And it's a little bit reflective. Treasury, again, I'm not a legal expert, what Van Loon versus Treasury. And I think the statement that was put forward, or the perspective, was that they're overstepping their statutory authority. And we've heard this a lot in the crypto space, right? Advocates in crypto, litigators in plaintiffs and defendants in crypto will often say, SEC, CFTC, you're overstepping your statutory authority. In your mind, and neither you or I are lobbyists or political people per se, but is that a winning argument from a legal perspective or a legal mind?
So I think it's a case by case analysis, right? It's facts and circumstances like everything else. So I think here, at least in this case, and there are other cases as well, including the one brought by Coin Center in respect of Tornado Cash as well, that remains ongoing. But one of the arguments has been, look, there are reasons for which people have non-nefarious reasons for which people want privacy, right? And they've given examples such as, well, what if you want to donate to a certain government, right? Or if you collect your pay in digital assets and maybe you don't want everyone knowing exactly how much you're receiving, things like that. And so I think that's one of the arguments being put forward. And part of the argument that's being made is saying, look, OFAC, Treasury, you're supposed to be able to sanction persons, entities, and property. And so the argument was made that, look, this is technology. It's a smart contract. It's not a person, it's not an entity, and it's not property. And I think what we saw in the judge's decision thus far in the Van Loon case is that the judge actually sided in this respect with Treasury and said, actually, there is a person, right? There's an organization, an unincorporated association, and looking to various aspects that I won't go into right now, but also saying that the smart contracts actually are property of the person/entity.
Right.
relating to tornado cash. So I think we are going to continue to test in other cases the bounds of statutory authority. I think it is an important thing to be focused on. And certainly, as I mentioned in this Van Loon case, there also were arguments about there being a taking or freedom of speech and things like that. What I can say is that at least if you look at what's been uh, tweeted about or xed about, whatever we're saying now,
It's a post now. You can't call it a tweet, I
yeah,
believe.
the post, yes. My apologies to everyone. It appears that this is a decision that folks intend to appeal. But I do think that just because in one case, particularly if it's involving matters of national security, just because a court may say, okay, we don't think this is outside the statutory authority, I don't think we should assume that because that decision is made in this scenario, that a decision might come out differently in respect, for example, of the major questions doctrine and a
Yeah.
different regulatory authority.
Right. Josh, you just said something interesting that keyed off a memory I had from one of our more recent meetings. Unincorporated associations, there's a business perspective. Well, it's not a company. There's no company, but that's not the precedent in law. And we don't have to go into the case law about it, but law and regulations looked at unincorporated associations. Is that correct? You don't have to be a company to be an entity under law and regulation.
That's right. I mean, without going into details, yes, an unincorporated association is a thing. So is a general partnership,
Right.
right?
Right.
And so these are some of the things that people have looked at, say, different forms of DAOs, because certainly there are some DAOs that are actually intentionally entities, and there are many different flavors of DAOs. But yeah, I mean, I think that's one of the things to remember is if you have a group of persons, there could be, under certain circumstances, again, facts and circumstances, there could be a recognition that this is in fact a distinct group, a meaningful group, as opposed to just disperse or diffuse sets of individuals.
Yeah.
And, some things, like if we think about general partnership law, just in general, again, and by the way, not legal advice, not investment advice, no kind of advice. But if you have a general partnership, I mean, then you can have joint and several unlimited liability, right? And
Right.
that's one of the reasons that people often don't want to, or one of the reasons for which people want to form, in certain instances, some sort of entity to limit liability.
Yep, and it's interesting. The definition of decentralized from a technologist perspective, I would argue, is looked at through a very different prism from law and regulation. You can be decentralized, but an unincorporated association, for example. And I think that's something that's important for us to keep an eye on. Josh, I know we're running short on time, and for everyone in the audience, thank you all for joining. We're going to make it a very brief session today. If you'll permit me, Josh, a little bit of a public service announcement. I don't know if you had seen the news, but obviously with some of the bankruptcies that have happened in the crypto space, Voyager certainly, BlockFi, cybersecurity is still a concern. And I had seen the blurb of news this morning that Kroll, the firm organizing and maintaining the proceeds and activity around the bankruptcy, had a data breach. And so you see these kind of cybersecurity concerns where scammers are targeting clients in the cybersecurity space, in the crypto space. So again, a little bit of a PSA, but folks out there, if you're involved in bankruptcy proceedings or a customer, be careful of the emails you look at and open. The scammers are really targeting this space as well. I wish David were here for one other reason, Josh. Not that it's not great being here with you, but obviously there's been so much price action in the crypto space. Ripple gave up, and I know I'm tearing up the script here, almost all of its gains post Judge Torres's ruling. Bitcoin, I think, is down 12% on the week, give or take. So that's some of what I'm going to be looking at. And Josh, what are you going to be focusing on? I know you've got a lot on your plate. What are you focusing on through the weekend and into next week?
As is sort of a common refrain from me, catching up on what I missed this week is a big one.
Yeah.
But I also think, behind the scenes, even as there, as you mentioned, there have been some price activities in the market.
Yep.
Clients and companies and projects are hard at work, and so definitely checking in and helping folks move along in that regard. That's really where my mind is right now.
One more announcement, if I could, Josh. For those of you interested in the audience, again, thank you for joining us on September 7th. We're having a global webinar on the tokenization of real-world assets. Shout out to our friend Richard Johnson and the team over at Texture Capital that will be driving that. This is, Josh, one of our open public webinars. So if anyone's interested, it's on LinkedIn, it's on Twitter, it's on Telegram. If anyone's not seen it, drop us a note, info@wsba.co. Please register September 7th, 11 a.m., tokenization of real-world assets. Josh, I'm going to leave it there. They just dropped on my desk the Treasury Department and IRS latest proposed rulemaking, and heads are exploding here at WSBA Central. So I will leave it there. Always a privilege. Have a great weekend, Josh, and thank you everyone in the audience for joining.
Thank you, everybody.
See you
Take
next
care.
week.